And the topic today is higher education, particularly in the perspective of the constitutional rights of the minorities. Shaila warned me that the time slot is too short for me. Therefore, I am very conscious of the time, not only of mine, but of you as well. One or two small things I would like to point out at this moment. I believe always that education is absolutely related to freedom. Free inquiry is the foundation of all education, right? Even you would all remember, Socrates was put to death by offering a cup of hemlock, the most poisonous substance in the world, because he was encouraging youngsters for free inquiry. Accosting, that is interaction, among the youngsters was the accusation on him. When he was offered hemlock, the sergeant who tendered that at the prison, he was holding that cup of hemlock, but his mind is set on something else. It is told that someone was singing at a distance and he was listening to the verses. The sergeant asked him, "Are you not afraid of death?" He said, "Let me learn something before I die." Therefore, the curiosity to learn sustained in him, even holding death in his hands. So, free inquiry is the foundation. Karl Marx, you might have read, Karl Marx always propagated the theory of inquisitorial instinct. Man should have the instinct for free inquiry. Today, what is happening at the higher educational institutions is some attempts, more political, are made to subvert this concept of free inquiry. Not only now, educationists in some 50, 60 years ago started this propaganda against suppression or political suppression of higher education. Some of you might have read the very first Higher Education Commission was appointed by the first Prime Minister of India, Jawaharlal Nehru, sometime in November 1948, just 1 year after the grant of freedom to us. It was chaired by none other than the great philosopher Dr. S. Radhakrishnan, with a companion of 9 renowned educationists across the country. They gave out the report saying that politics and education should be separated. He wanted, Dr. Radhakrishnan and his team of people wanted, education should be freed from politicians. Why I am using the expression very carefully, politicians, is because I don't say education should be separated from politics, but it should be separated, no doubt, from politicians. Because he is citing the statement of dying Goethe that freedom, light, and the Ajax in the mist saying or crying for light, more light, though I die in it. This concept of free inquiry, freedom, autonomy in higher education has become the target of the politicians of the day. You will permit me to read 1 or 2 lines of what exactly Dr. Radhakrishnan told in his report. Freedom of individual development is the basis of democracy. Exclusive control of education by the state has been an important factor in facilitating totalitarian tyrannies. In such states, institutions of higher learning, controlled and managed by governmental agencies, act like mercenaries, promote the political purpose of the state, make them acceptable to an increasing number of their population, supply them with weapons they need. We must resist, in the interests of our own democracy, the trend towards governmental domination of the educational process. Higher education is undoubtedly an obligation of the state, but state aid is not to be confused with state control over academic policies and practices. Intellectual progress demands the maintenance of spirit of free inquiry, the pursuit and practice of the truth regardless of consequences has been the ambition of universities. Their prayer is that of dying Goethe, more light, or that of Ajax in the mist, light, though I perish in the light. This is the motto which was propounded in the very first report given by the very first commission appointed by the very first Prime Minister in this country. Over the years, what we have been witnessing is more and more political control, politicians are trying to intervene in the academic policies. Therefore, I would just place it for your consideration that your endeavor shall be to free education and educational institutions from the politicians' hands. That's the first one. Second one is, it is common knowledge and it is an universally accepted factor. In India, minority educational institutions always are far better than other educational institutions. Why? Because more autonomy is given to the minority institutions regarding their academic and administrative governance. More freedom, more pursuit towards the truth, more autonomy, more excellence, more accomplishments. That is what is happening in minority educational institutions. There was a time, almost 22 years ago, when we were arguing certain matters before the Supreme Court. One of the arguments advanced by the government was, we want to regulate, we want to make regulations even in the governance of minority educational institutions. Why? Because it is the government's obligation to ensure that minority institutions do not fall below the standards. Because it's the governmental obligation to maintain standard. It is our obligation, government's obligation, to ensure minority institutions don't fall below the standards. That is why certain amount of regulations, governmental regulations, should be permitted even inside minority institutions. Fali Nariman, you might have heard about, the famous lawyer, he stood up and asked, let the government first say, name one minority educational institution which has so far fallen below the standards. There was no reply at all. On the other hand, minority educational institutions have been setting themselves as role models for excellence in education. That is a proven factor. If you look back at history, why this minority rights is related to education, there is a very dominant role played by this Jesuit society in the gaining of that education as a fundamental right. If you look back in the 1940s, you all know that the Constitution was made by a large body of 272 persons, deliberating, discussing and deciding over a long period of 2 years, 11 months and 17 days. Dr. Ambedkar was the chairperson of the drafting committee. In the course of these deliberations, there was a lot of debates, a lot of compromises made by various communities, various sectors of the people, ethnic, linguistic, religious, so on and so forth. Coming to the rights of the minorities, the leaders of the minorities wanted reservation in the electorates and reservation in the bureaucracy. To put it otherwise, they wanted particular number of seats always reserved for them in the parliament, in both houses, as well as in state legislative assemblies. So also in this bureaucracy, from IAS, IPS, so on and so forth, down up to the panchayats. These were the demands by the minorities. Britishers were telling, on the other hand, in the British Parliament, unless you agree to the demands of the minorities, we will not confer you with the freedom. Why? Because you are going to adopt a democracy as the rule of governance. Democracy is nothing but the rule of the majority. What will happen if you make laws by majority? The rights of the minorities, what will happen? Therefore, unless you ensure and satisfy the demands of the minorities, we will not hand over freedom to you. That was the debate that was going on in the British Parliament. So, in reply to that, our leaders said that we will protect this and that. At the end, when the demands for reservation in politics and reservation in bureaucracy was demanded, great leaders like Mahatma Gandhi, Nehru, Patel, so on and so forth, all those people persuaded the minority leaders. Please don't try to identify always yourself with reference to language or religion. Give up that. Please come out with any other demand. We are prepared to oblige. And the days were set, and our minority leaders were so magnanimous, they decided to give up those demands. Later, when the day was set for the placement of the demand, it was a great shock for the entire Constituent Assembly because two gentlemen, Father Jerome de Sousa, a Jesuit priest, and Mr. Frank Anthony, an Anglo-Indian, both rose up and said, "Give us education as the fundamental right." It was thought very, very simple, small at that moment. But today, after the passage of 75 long years, we understand how far-sighted those two gentlemen were. They probably thought, why this electoral reservation? Why should we get elected or appointed on the basis of reservation? On the other hand, we will make our people more educated. Education will take care of itself. They will occupy the bureaucracy. They will occupy the seats in the legislative assemblies and parliament. Probably that would have been the great idea. Today, we are great as minority institutions, not only serving the minority community, but serving everybody. We don't deny admission to other community people. But this excellence became possible only because of the little autonomy, the little freedom, what our institutions enjoy. I would stop by telling one more aspect of this matter, the state of complacency. First is freedom shall be the foundation of higher education. Second is minorities' autonomy favored for the excellence achievement. Thirdly, complacency is the problem today. We all believe that our forefathers, maybe people like Jerome de Sousa and Frank Anthony, were so brilliant, so far-sighted. They accomplished all these rights for us. They got these rights enshrined as a fundamental right in the Constitution. Therefore, we are all safe. This is the complacency we develop nowadays. Our leaders proved to be timid in contradistinction with boldness and courage nowadays. They all wrongly believe that the Constitution is there, Article 30 is there. It is no doubt a fundamental right which has been accomplished by our forefathers. Therefore, we are all safe. Let us all live in complacency. It is thoroughly wrong. It is a fallacy. We must always remember that we are all minorities. We are never going to muster majority. We have to live as a minority all the time. But the sheer spirit of inquiry, the spirit of freedom, the spirit of agitation shall be the guiding factor. It is famously said by one Justice Learned Hand that liberty lies in the hearts of men and women. When it dies there, no constitution, no court, and no law would be of any help. The other idea that our forefathers achieved, therefore we are inheriting all the rights, is again wrong. One of the famous lawyers who argued several cases in favor of the minorities is Advocate Senior Counsel Palkhiwala. You might have heard about him. Even though he succeeded in case after case before the Supreme Court, but still he has a word of caution to the community saying that freedom shall never be inherited in the bloodstream of men. Each generation has to fight for it to preserve it. Freedom is never a final accomplishment. Please remember, No generation can afford to say, my previous generation has accomplished it. Freedom is never a final accomplishment. It is, on the other hand, a pursuit. Each generation has to carry that fight to preserve it. The attitude of complacency is completely condemnable and will render the society, our community, exposed to very many dangers. It is because of the autonomy, it is because of the rights of the minorities, we are able to excel everywhere. And let us be careful in the preservation of that rights. I hope that this will be sufficient, and if one or two of you have any questions to ask, please feel free. Yes. What about the time?
You like to be seated, sir, or you want to?
Yeah.
The governance of minority higher education institutions is a big challenge here. We are here to look at from the perspective of the Constitution. Law is one hand, our rights is another hand. Sir has very well explained the nuances of getting the minority rights based on education. Our forefathers were very great and intelligent enough. If we give education, that is power. Now, we are in crossroads of the history. One side it is the politicians, another side it is the bureaucrats. How to maintain our minority institutions? The questions are raised. Please come forward to ask the most experienced person in this field. Anybody?
Yes.
Yes, sir.
So good evening, sir.
Yes.
So from 2017 to 2024, almost 50 appointments have been made in the government aided stream in Loyola College, out of which 19 appointments, the government of Tamil Nadu has not given the posting approval, even though they are sanctioned posts. And for almost 30 people, the University of Madras has not given the qualification approval. What is the legal remedy to address this problem, sir? Because it is affecting the livelihood of many families. And on a personal note, we request you to address this case and then do something for us so that, minority rights can be reinstated again. Thank you, sir.
From the clap, I could understand several people are sitting here who are waiting for approval from the university as well as from the government. No doubt, as Sir asked, the remedy is legal. In fact, I would, as a matter of great pride, say it is the Loyola College which actually spearheaded this problem sometime in 2010. And Shaila was actually heading the team when she was leading that agitation. She not only organized the people of this college, but almost 7-8 colleges in the city of Chennai. 2006-07, almost 350 faculty members were appointed in various colleges. Out of the 8 colleges, 7 college principals remained unapproved. Only one, he was already approved, he was continuing. That was the situation. But nobody had the guts to fight. It was 2006, 7, 8, 9, 10. Only when they reached the edge, they were pushed to fight. In 2010, Father Pushparaj and his team of people, Father Joe Arun, the secretary here, and Shaila, all these people took the initiative, and we challenged the non-approval of those 350 faculty members and the 7 principals. The reason for the denial of approval by the university as well as by the government was there was a University Grants Commission regulation saying unless these people are appointed through a selection process, through a selection committee composed of 7 people, we will not give you approval. The 7 people who composed the committee were not the management people, only 3 from the management, 4 from the university. The regulation said decisions ought to be taken by majority. Obviously, the outsiders are majority 4 and the insiders are only minority. We opposed that. We made all these appointments without reference to that committees. Therefore, all our appointments were denied approval. Then when we found the University Grants Commission regulations were staring at us, we chose to challenge the validity of the University Grants Commission's authority to make such regulations against minority institutions. That was argued by us in the Madras High Court, and the High Court said UGC has no business. As long as the minorities have the right of autonomy or the right to make appointments, you can't say they shall select somebody through some body or some committee, except saying the educational qualification required for each one of the posts, you have no business to interfere. You don't want to suggest to the minority institutions how they should form committees and compose these formations and select people. It is up to them. The High Court quashed all those regulations, and Pat came this approval from the university as well as from the government. All of them got their salaries with all arrears at that point of time. That was in 2000. The year 2000 was the regulation which was successfully quashed in 2010. When in the course of arguments in this High Court, when we were arguing that how can the outsiders, majority they can come inside. We do not know them. We do not have any identity with reference to religion or language. How can they come and sit with us and select? Realizing this argument, that it was slightly finding favor with the court, the UGC woke up to the situation, suddenly announced a new regulation 2010, saying that, yes, we agree, the three from outside, the three from inside and the four from outside shall be chosen by the Vice Chancellor of the university from and out of 20 plus 20, 40 people given by the college as a panel. Therefore, the Vice Chancellor will have no other option except to nominate people from your own panel. Now you can't say outsiders. That was the argument. They framed the regulation and placed before the court. Therefore, there can't be any more complaints on the side of the minority that outsiders are coming in. For which our further argument was, first let the University Grants Commission establish its authority to tell us either good or bad. Maybe good, but who are they to tell us? We have the administration power under the Constitution. How can a small commission sitting at Delhi tell us what we should do and what we should not do? Maybe what they are suggesting is good, but who are they first? Court accepted that argument and said that University Grants Commission has no legal authority to even to suggest good things to the minority institution. It is left to them. Whether it is good or bad is left to the minorities. No outside agency like University Grants Commission can suggest it. That is how even 2010 regulation itself was quashed. Eventually, all these 350 plus 7 principles got approval. Now what happens is, the laws remain the same. University Grants Commission's lack of power is still the same. Right of the minority institutions is still the same. But the problem is, now there is another regulation, 2018 regulation, announced by the University Grants Commission. Of course, you know the political situation at the center now. Again reiterating the same thing, saying that there will be a committee with more people now, and they should sit and select. The universities are obliged to that. Very pathetically, the state government also adopted it. I don't know why this state government is adopting it, notwithstanding the factor it is already laid down by the courts that such regulations are bad. The other factor is some political announcements are being made by the parties that we shall be the Aran for the Sirvan minor. But when they come to the power, I don't know why they are not agitating against it. They could have simply said, we don't adopt it. But unfortunately, the government of Tamil Nadu has adopted it, and the Madras University and all other universities are simply bound by that. But anyhow, now there are several cases, both in the Madras High Court as well as in the Madurai bench of the Madras High Court. Numerous cases have been allowed, saying that Though 2018 regulations talk about the composition of committees and selection system, but the law remains the same. Where is your power to suggest that? Therefore, to your question, my answer is, you started with the question, where is the legal remedy? My answer would be, the remedy is legal. We can certainly agitate if there is a still problem, and we can definitely find something favorable to you.
Thank
Right?
you, sir. Thank you. Is there any more question? Yeah, last question. There is one person. He said he is from Vadamilpakkam.
Check. Thank you, sir.
Kindly introduce yourself and then ask the question.
Hello, sir. My name is Juban Solomon. I'm an alumni of Loyola College. And my question for you is, in this prevailing totalitarian environment, I'm not saying all, but most of the minority institutions, as we are speaking about the governance of minority institution, most of the minority institutions have a centralized way of governance. Do you think it is the right way of governance to go against the totalitarian environment, or should we have a decentralized and distributed authority system for us to go against the totalitarian environment?
Yes. Yes, according to you, the regime is a totalitarian. We are centralized and not we are decentralized. Centralization or decentralization shall be your choice, the minority institution's choice. Totalitarian tyrannies is always possible at the hands of the politicians. But please remember, minorities are never born with full freedom. They are born under some kind of threats, some kinds of bondage. It is by sheer fight we have been establishing these rights. If we start thinking that we should be born as a free citizen, as a free community, and we should always live safe as a minority community with all freedom, it would never be possible. And I do not know on the linguistic side, but I am sure on the religious side, especially as Christians, Christianity is born in trouble, lives in trouble, but still succeeds amidst all troubles. That is our position. Let us not be scared, let us not be afraid whether we should centralize or decentralize depending upon the political environment. It is our environment that matters. It is our environment. Even the Constitution of India was framed amidst all the difficulties. One of the famous statements by a jurist, English jurist, Granville Austin, he says, at the time when the fundamental rights were framed inside the Constituent Assembly, there was absolute peace and calmness. But the situation outside the Constituent Assembly was absolutely different. There were ghastly murders, mutilated bodies lying here and there in the drains and sewage. Curfew announced almost in all parts of North India, but there was absolute peace and calmness in the deliberations inside the Constituent Assembly. In his beautiful words, he says, it is an irony in history that fundamental rights were to be framed inside amidst the carnage of fundamental wrongs outside. Therefore, this is nothing new. Christ was killed and he was crucified. On the cross, we have constructed the church. We are living so long amidst all the trouble throughout the world. And I tell you as a word of caution, if no trouble, no development, no excellence possible. Excellence is always possible amidst all troubles. Let us not be afraid of that.
Thank you, sir. Thank you.
Yes.
Kindly be seated, sir. for a
Thank you
few-
so much.
Thank you,
Thank you.
sir. Thank you.